Hello everyone, thanks for coming along tonight to VAC's third community forum for, that we've been doing now. We've been doing regular community forums and we've formalised it into a monthly situation. And tonight we are partnering with Living Positive Victoria, who are our partnership or community partner organisation. So it's great to have, I think I saw Ian Muchmore here, their president, and other people from Living Positive Victoria. So it's great to be partnering with our community partner tonight. In what has been a big year for the HIV/AIDS sector in Melbourne, we had the AIDS conference in July. We've had a range of satellite events that happened before and after the conference. It has really been a very big year, and our last forum tonight is on HIV and the law, which has been a very topical issue this year. Both before and during the AIDS conference, both the major parties made commitments to reform laws that criminalise transmission and exposure of HIV in Victoria. As most of you, I'm sure if not all of you know here, we have a new government in Victoria who has made various commitments to change HIV laws in Victoria. So it is a topic tonight that I think speaks of really the most visible topic in the HIV/AIDS sector in Victoria, in particular because of the changes and the potential effects that those changes could have on people living with HIV. We have two speakers tonight to address this issue. Paul Kidd is going to speak first. Paul is the chair of the HIV legal working group. Paul has really spearheaded with Ian Muchmore many of the activities and much of the advocacy that led to the announcements before and during the AIDS conference. Paul is going to speak about the advocacy work that VAC and Living Positive Victoria have done to get those commitments and a little bit more about HIV laws in Victoria and the public health model. He'll also look at and go over some of the commitments that Labor particularly made and that Labor will, we hope, fulfil in the next year. I've also got Simon Moglia here. Simon is a lawyer with 14 years experience. He's been in court, I think, for the last week in Geelong, so I'm very grateful that he's been able to put the time in and commit to come here tonight to speak about HIV laws in Victoria. As I said, he's got 14 years experience as a solicitor and barrister. He's appeared in HIV cases in Victorian courts, has the bulk of his practices in the county court, I think, if that's right, here in Victoria. And obviously he's a registered lawyer, so I'm very grateful that Simon can once again, I think it's the fourth forum he's helped us in over the last year, can come and speak from a lawyer's perspective, and he will really talk more technically about legal processes in Victoria, statutory law affecting people living with HIV, and also case law. And he will also, like Paul, touch on the public health model, which is an alternative model to addressing people who are putting others at risk of HIV. After they've spoken, we will have time for questions, and I encourage people to engage with the question and answer part of this evening. What we've done is we have handed out a little piece of paper to everyone, and if you haven't got one, we'll make sure you get one. You're welcome to ask questions from the floor, or you can write a question down, and John Manwaring over here will collect those after the presentations and bring those up to me, and I can ask them from the floor, ask them from the lectern here. So there are two options, and we really want to make sure that everyone gets an opportunity to ask any question that they want. So with this said, I'm going to ask Paul Kidd to come up and talk about the work that VAC and Living Positive Victoria have done in the last 12 months to bring about some of the commitments that Labor, we hope, are bound to.
Thank you very much, Heath, and hi everyone. Good evening, and thanks for the opportunity to address this forum. So what I'm going to do is just talk about the way the two different sets of laws in Victoria operate with relation to HIV. So that's the public health law and the criminal law. And I'm going to talk a little bit about the advocacy process that we've undertaken towards the reform of the criminal law and the other work that we're hoping to do in that area. So as I say, there are two different sets of laws that affect people with HIV directly in Victoria, and one of them is the criminal law, and Simon's going to talk much more about that. I'm going to focus a bit more on the other side of the law, the public health law. And I think one of the problems we have is that there's a lot of people don't realise that there are these other processes that exist and that operate. And in fact, most of the people with HIV who come to the attention of the authorities come under the public health and wellbeing process, not under the criminal law process. But I think, as I say, it's a much less well-known process. But it's also a very powerful process. It's a very effective process, and we believe, being VAC and Living Positive Victoria, both organisations believe that the public health law provides the best legal response to HIV where people are alleged to have placed other people at risk. So the Public Health and Wellbeing Act of 2008 is the new Health Act, a relatively new Health Act in Victoria, and in particular it provides some very significant powers for a statutory officer called the Chief Health Officer. That's Dr. Rosemary Lester is the current occupant of that position, and she has really quite considerable powers, not just in relation to HIV but in relation to public health generally, and her duty is to protect the public health of the people of Victoria, and also she has powers that enable her to control the behaviour of people who are alleged to have to place other people at risk, or she has powers to control industries and processes that may place the public health at risk. As far as HIV is concerned, the key process that applies, we call it the guidelines process. It's technically called the Guidelines for the Management of People Who Place Others at Risk. It doesn't quite trip off the tongue, so I'll just call it the guidelines. And that's a process that was established here in Victoria quite some time ago. I think it's almost 20 years that we've had this process operating. It's a model that's been exported to other states, so every state in Australia now has a similar guidelines process. And it's, as I say, very well established process that kicks in where an allegation is made against someone who's alleged to have placed someone at risk of HIV. So it's a 5-step process, and the intention of the process is to do the minimum necessary intervention to achieve behaviour change that will protect public health. So obviously any kind of process that intervenes in people's lives potentially is restricting their rights, and so it's a process that's designed to balance rights with public health against each other and to do the minimum necessary in order to get the right result. So the 5-step process begins with basically counselling and education. So people are told what their responsibilities are. They are the process establishes that people know how to protect themselves. They know about safe sex. They know what their obligations are. It then, if that doesn't work, accelerates to the next level. And the next level is a letter of warning in which people are told essentially you're about to get in trouble unless you change your behaviour. And then the next stage that's fairly well known is a public health order, and a public health order can order you under legal penalty to change your behaviour, to not engage in certain kinds of sexual acts, to undergo testing or treatment for HIV or other diseases. It can order you to stay away from particular places or particular classes of places. So very considerable amount of power that's vested in the Chief Health Officer there. And then the 5th level, the most stringent level, enables the Chief Health Officer to do things like isolate and quarantine people. So they can literally have you arrested and locked up without trial. The good news is that very rarely happens. To my knowledge, in the last decade, only one person has ever got to that level 5 process. Almost everybody who comes before the public health process is dealt with at the very lowest level, and in almost every case, it's a very successful process. People mostly have one meeting with the part notifications officers. The allegation is discussed. People are given information and education that they need to change their behaviour, and then they're not heard from again. That's the end of the process. And the good thing about that is it's a private process. It happens in private, behind closed doors. If you are arrested and taken before the courts, it's extremely public. And regardless of whether you're guilty or not, regardless of whether you're prosecuted or not, regardless of whether you're ever convicted or not, that process exposes you to incredible public scrutiny. You'll commonly have your name published in the newspaper, and you never get that privacy back. You're exposed in the press as a person who has allegedly exposed other people to HIV. That's one of the reasons why we really prefer the public health process, because it's about fixing people. It's about taking something that's alleged to be wrong with people, identifying where there's a problem and fixing it and enabling them to go on with their lives. The criminal justice system is about punishment, and it breaks people. As soon as you come into the criminal justice system, you are damaged by it and you remain damaged by it forever. There's a panel of experts and community representatives that advise the Chief Health Officer about the process. As I say, it's a highly successful process. It almost always works. Sometimes people have to be escalated to other levels. The public health process can refer you into the criminal justice process. There has been one rather infamous failure of that process, which was the Michael Neal case. I think I can say that since the Michael Neal case, and that case cost the Chief Health Officer his job, he was sacked over it. Since the Michael Neal case, I think in some senses the pendulum has swung a little bit too far to the conservative side, but overall I think the process works really well. VAC and Living Positive Victoria have a united view that the public health process provides the best possible legal response to the allegation of people putting people at risk. As I say, it's a process that's about fixing people. It's about behaviour change. It's about protecting the community into the future. It's not about trying to punish people for something they've done in the past. Our view is that the laws in Victoria need to operate more closely together, and they need to operate in compatible and rational ways. The key issue here is that HIV is a health issue. It's a health issue. It is not a law and order issue, and it should be treated as a health issue first and foremost. So our view is that criminal prosecution of people for either exposure or transmission of HIV should be a last resort. It should only ever be considered in cases, we believe, where transmission has first of all actually occurred. So we don't think that it's ever appropriate to prosecute someone for exposing someone to HIV. And secondly, only in cases where that transmission occurred intentionally. So there needs to be intention and there needs to be actual transmission. In order to get those two laws to work together better, our view is that there are two things in particular that are needed. And one of them is prosecutorial guidelines. The second one is about repealing Section 19A. Prosecutorial guidelines we've been advocating for 3 years now. We haven't got there yet. We've had a number of meetings with the Office of Public Prosecutions about it. They're interested in the idea. Things move a little bit too slowly for my liking, but we'll continue that process. The way they would work is that first of all they would clearly enunciate a government-wide policy that HIV is a health issue, and it would clearly enunciate that view that the criminal justice system should be the last resort. Would provide a formal way in which the prosecutors can transfer the case into the public health process. And we believe that can be done without legislation. It's already within the power of the Director of Public Prosecutions under the kinds of prosecutorial discretion that he has in order to do that and to look at the public health system as an alternative to prosecution. We think it's a great win for the society as a whole because it would save a considerable amount of money. Prosecuting people and taking them through the courts is very expensive. As I say, it's focused on getting the future behaviour right, and we think that it will have significant benefits for the HIV community and the affected community as a whole, because it will reduce the number of prosecutions and reduce that media frenzy that happens every time somebody gets prosecuted that really drives HIV stigma. The second thing is the one you probably have heard a fair bit more about, and that's this one, repealing Section 19A. So Section 19A was added to the Crimes Act 21 years ago in 1993. Obviously a very different time in terms of the history of HIV and the experience of HIV at the time. So it was produced in response to some fear about syringe bandits. There was one particular case that happened in New South Wales in a prison where a prison officer was stabbed in the behind with a blood-filled syringe from a prisoner. It was a very unpleasant case. Both the prisoner and the prison officer later died. So in response to that, we have Section 19A, and when you look at the way it was brought in, you look at the media reports at the time, you look at the Hansard, it's really clear that it was brought in response to specifically this issue about syringe bandits. There has never been a case in Victoria of an HIV-positive person threatening another person with a blood-filled syringe. There's never been a case of HIV transmission with a blood-filled syringe in Victoria. The purpose that law was brought in for simply has never eventuated. What has happened instead is that it has been used against people with HIV it's been used in cases of sexual transmission only, and it's used as a threat against people with HIV. We know that it's dangled over them as a danger, and it's a very serious crime. It has a 25-year maximum jail penalty. That's the same maximum jail penalty as you get for manslaughter. It's one step down from murder. It's completely contrary to most informed thinking about the way we respond to HIV. It's a very counterproductive to the HIV response. It doesn't have a deterrent effect, both UNAIDS, the WHO, the International Commission on HIV and the Law, a whole range of international bodies have really clearly said that HIV-specific criminal laws are inappropriate, and Section 19A is Australia's only HIV-specific criminal law. So we want repeal because, first of all, we say it's redundant. There are other sections in the Crimes Act that are equally capable of dealing with that situation. We certainly are not saying that someone who intentionally transmits HIV should be able to go free, that should not be a criminal act. What we say is that there are offences of general application that are the appropriate ones to use in that case. We don't have a specific criminal law about hitting someone on the head with a stick. We don't have a different criminal law about hitting someone on the head with an iron bar. We don't need a specific criminal law for HIV. We have general laws that work. And the other problem with Section 19A is it's terribly stigmatising. It sits there as a kind of artefact of a time when people with HIV were seen as a threat, and it continues that idea that people like me are a threat to public safety. And we know that's absolutely not true. People with HIV are the leaders in preventing HIV transmission in Victoria, and it's an absolute insult, frankly, that we have a law on the books that treats us as the problem. And the other problem with it, of course, is that it doesn't work. It's just simply never been applied effectively. I've gone way over my time, haven't I? I'm on my second last card, though. So what we've done is that we set an advocacy plan. It was around the conference, and we set out basically a three-stage process, that we would set out a case for repeal of Section 19A, that we would build dialogue with, particularly with legislators and with community, and then that we would use AIDS 2014, the conference, as a platform to really focus on this law that we're really, we believe Victoria should be embarrassed about. The great news, of course, is that the day before the conference, the Health Minister announced that the coalition government would amend Section 19A to make it non-discriminatory against people with HIV. Had a few problems with the language there, but that's as far as we got with them. That's the language they were still using 2 weeks ago when we had our election platform. The last day of the conference, the Labor Party came on board, and they, I'm very pleased to say, undertook to fully repeal Section 19A, which we think is the only appropriate response to this law. So that's a commitment that they made during the conference, and that has been repeated since. Obviously, we have a new government, and we have a Labor government in Victoria. This is good news for us in terms of Section 19A because we have an absolutely clear commitment that it will be repealed. We also have a deadline by which it will be repealed. The Labor commitment is to repeal it by the first anniversary of the AIDS conference. So that's the 25th of July. We are obviously looking to see what the makeup of the upper house will be because that can have some impact on the ability to pass this. The good news is that the minor parties, the Greens, are absolutely committed to repealing Section 19A. Looks like Fiona Patten from the Sex Party will be in the upper house. They're absolutely committed to repealing Section 19A. The Coalition, who will be the opposition, they get it. We feel pretty confident that we've got our message through there, and we'll certainly work with them to make sure that this law, when it comes to the Parliament, goes through. So that's where we're at with Section 19A. As I say, prosecutorial guidelines are the other thing that we're working on. We'll be working on that in the coming year. Thanks very much.
Thanks, Paul. And just to build on that, as I said, we've got Simon Moglia here, who is a practicing lawyer who will talk more about the technical side and the procedural side of Victorian HIV laws. Simon.
See if my toys work first. Woohoo. That's me. HIV and crime is not just about the law. It's also about the process of the law. It's about who plays a part in the process of the law. And as Paul's outlined really helpfully, I think, it's also about alternatives in the law, because the Health Act is part of the law rather than just crime. What I'm hoping to do here is to give you, who perhaps don't have as much experience as others in criminal procedure, just about what shape does it take when the police respond to a complaint about something, and who do you have to deal with and in what forums. It's nice and easy to imagine Constable Plod as the guy you go to on the corner and say something's happened, and they might charge and put you in front of the local magistrate. It gets much more complicated, particularly in areas of law such as public health issues and endangerment or recklessness or even intention. We usually see that the courts and the prosecutors take a pretty serious approach to investigating and working out whether or not what's been done is criminal. So there are plenty of parts and there are a lot of players. From top to bottom, somebody might well have a complaint about something. They might not have it formulated, but it's probably somebody you know or somebody you've had contact with, person number one. They'll talk to police. We add police to the list. The police will interview you, and you are charged. The next person that becomes involved is probably, hopefully, I don't just speak from personal interest, you get a lawyer. They'll engage with negotiations with a lawyer from the Director of Public Prosecution's office. And we're adding as we go along. The person who makes the complaint stays involved, and the Charter of Victims' Rights in Victoria ensures that police and the Director continue to consult with them. Police are involved and conduct investigations and the like. Negotiations might happen. If there's a committal hearing, a magistrate will be involved in hearing things. That's usually a place where we see publicity coming to the fore. After that, there's preparation for a trial, and you add a judge into the mix who's dealing with your lawyers and police. And ultimately, a year or two later, I'm sad to say, you might see a trial, and of course there's 12 more people. Lawyers will get involved in anything, I know, but if you're charged, or if there's somebody who's laying an allegation, your lawyer can help you understand what your options are about how to respond. They can talk with you over the phone or come to the police station with you if you're about to be interviewed about a suspected offence having occurred. Your lawyers are going to help you negotiate with police and then with the Director about charges, and I'll come to it a little bit later on. What are the alternatives, and why should we keep going down this track that the charge or the complaint has started? If you're lucky or unlucky, depending on your view about me, you get somebody like me who will appear in court down the bottom. That's because the case has continued on and everybody's position is, generally speaking, so entrenched that this has to be given to a jury. It's not to say things can't resolve or settle before then, but you can see that lawyers simply represent the complexity of the proceeding. Here's a list of charges. It's my view about the kinds of charges that could arguably be laid against a person who, it's said, has put people at risk or actually infected another person. There's plenty been said about 19A, and I won't go through that anymore. It does attract a 25-year maximum. Jan Wade, when she brought it in, talked about blood-filled, syringed armed robberies, for example, and why, with the scourge of drugs and people desperate for money, there needed to be some control on that. And clearly, dovetailing with the hysteria wouldn't be too harsh a word to place about the prison incident in New South Wales. By coincidence, I've listed these in seriousness order. 25-year maximum for 19A, intentionally causing a serious injury. We see that charge for a glassing, a very serious assault, something that really causes something that's going to last by way of injury, 20 years. Recklessly causing that kind of injury, i.e. you didn't intend it but you thought it was likely to result, 15 years. Reckless conduct endangering life, that is, the risk is somebody's going to die from what you did, 10 years. And reckless conduct in relation to something that's just going to seriously injure somebody, 5 years. The old Health Act used to have an offence provision in it which didn't attract prison under section 120. That Act is now repealed, and we see that public health is not about offences but about interventions like Paul described. These are the kinds of issues that come up in prosecutions. Complaints often arise out of anger. We see that all the time, and it's natural. People feel aggrieved and they want something done. They want somebody to do something. We don't live in a police state, contrary to what some people say, but people do rely on police to fix and advise them about a whole range of things that aren't necessarily criminal matters. Domestic violence is certainly a criminal matter. Domestic unrest might not be, and yet police are often the first person on the scene and the first or key people to advise people about what their options are. So when there's a complaint, police regularly hear about it. And it's police officers who have to decide, well, what's the appropriate course? There isn't a specific guideline about when does Constable X say, I'm going to take you down the public health track and introduce you to the contact tracers or the notification officers, or try and get some help in a more holistic sense in that way. Or, under the pressure of investigation and policing, it may simply be that the easier way for them is to say, fine, I've got a name of the person you say offended, I'll charge, and then we'll get some evidence together and we'll work it out that way. And the charging, and ultimately a sentencing, if we get that far, will do that work. It'll deter them from doing it. It'll teach them a lesson. It'll get them to go and get some help. Whatever the issue is that the person's complaining about, perhaps it's valid, I'm not sure. Police think, well, charging is a way of getting something done. Endangerment charges are the bulk, take account of the bulk of cases that we've seen in Victoria. We don't see 19A charged very often. As Paul said, it's sometimes charged as a way of achieving another goal, getting some traction on a lower level offence perhaps. At the very least, we regularly see it withdrawn by the director if it gets that far. But what we don't see withdrawn are the endangerment charges. Endangerment in the law is a hard concept, and I think this example might give you a way of understanding it. Imagine somebody's got 3 envelopes. In 2 of the 3 envelopes, that is, if you're going to pick one randomly out of the 3, you're likely to pick one of these 2, right? In 2 of those 3 envelopes, there's a lotto ticket. You know, we all know that there's a good chance you'll win when you get a lotto ticket, right? We'll call that the ultimate risk. But by picking one of the 3 envelopes, you are reckless, to put it positively, you're making a pick that results in a likely result. So it's likely, 2 out of 3, you're likely to get an envelope in it with a lotto ticket. Okay, that's the example. Let's put it into sexual relationship context. If you engage in an activity that has a risk, this is the lotto ticket bit, and it might be a minor risk, it might be a 1 in 200 or a 1 in 2,000 risk of transmission, but it's just a risk, then if you do something that introduces a likelihood of that risk coming about, so this is the picking the envelope bit, unsafe sex, sharing of a needle without any clean needle. So that's the likelihood bit, that you're doing something that's likely to engage a risk, even if the risk is only 1 in 200. We can talk more about it. But you can see that the law of endangerment is extremely broad, and it'll depend on what you said you said it, in the circumstances that were, what your viral load might have been at the time, whether it was measured, whether you were aware of it, how often sex was engaged in, what kind, how dangerous it was, whether there are any other STIs that might increase risk of transmission, etc. You know the deal, you've seen the material. So if you do something that means that that risk is likely to be on the table, endangerment charges are made out. They're very broad. What we've seen is that over time, though, the science has seen the law catch up a bit. We're no longer talking about putting people at risk of death. HIV is not a death sentence, it's a chronically treatable condition. The law now seems to be charging endangerment of serious injury more often. In fact, in recent years, that's been the only charge that's been at trial. And in the last couple of years, there's been very few, and I can only think of one in the last 5 years. The next issue is likelihood. Okay, what is the risk in the envelope? Is the lottery ticket going to come true? Is the transmission going to go ahead? Well, the expert evidence in a trial might be, well, in these circumstances, there was probably a 1 in 200 chance with one insertive act of sex. It might be because of the kinds of sex or the kind of interaction, it's 1 in 1,000 or 2,000 because of viral load, and it was measured at the time. Wasn't measured at the time, we all know there can be spikes in viral load. Maybe an expert's only going to say, oh, I'm not going to say it's that small a risk, I'm going to say it might be 1 in 150 to 200. What does a jury make of that? They might accept the expert is right, that this is a 1 in X chance, but what does that mean in my actual situation where we had this encounter? So there's likely to be expert evidence in a case. There might be inferences about intention. What's an inference? An inference is you find that something's true because of the surrounding facts. I infer it's day outside because I can see what I think is daylight and there's a lot of traffic. I can see the clock. It's usually not wrong. But intention to put somebody at risk can be made out not because you admit it, not because they can get inside your head, but because they can infer it from the circumstances around it. And cases have been run on the fact that the defendant was told he's got HIV, that he should take precautions, but after a while in the relationship stopped using a condom, or after a number of relationships commenced another relationship and didn't use safe sex practices. You can infer from that that aware of the risk, knew why he should, intended to do. Undetectable viral loads, I think I've addressed that. It's hard. It's certainly comforting to think that if the viral load's low, I'm not going to transmit, so I can't be guilty. Don't think the science is there with us yet. I don't think we can unequivocally say that an undetectable viral load at one point means it's always going to be undetectable or always going to be low risk. There are some cases in Canada that say because in a situation the court could be certain that there was an undetectable load, there wasn't an appropriate level of risk to found a conviction, but it'll turn on facts, it'll turn on expert evidence, it'll turn on appreciable risk, and what does that mean in the circumstances. Defences, if you disclose, if you use a condom, if you use PrEP, Will this mean that you can't be guilty of an offence? My advice would be very cautious about adopting that view. Epidemiologically, you might think that PrEP is pretty damn good. Condoms, probably the most proven good in terms of safe practice. Let me leave disclosure for a minute. But these cases are always questions of fact. It's always going to be what evidence goes to the jury. What's the expert going to say? What's the complainant going to say you said? What are the circumstances? Disclosure. In Victoria, since the Neil case, disclosure has become a defence to the endangerment charge. So if you disclose your status and the person with whom you're engaging in even risky behaviour makes an informed choice to go ahead with the behaviour, it seems that, at least in relation to one of the endangerment charges, that goes in your favour. But my purpose for putting this list of things and saying that from go to woe is a couple of years, be very careful about putting all your eggs in one basket. You don't want to do something in the hope that the expert's going to save you and you're going to convince the first police officer you speak to that that's the case, because it might take you 2 years to get before a jury to be able to run the defence. Crime is not the way to go. I completely agree with Paul. We have alternatives and we should use them. We have the public health procedures, very effective, have been used in at least one of my cases and achieved everything that the criminal courts could have achieved. Alternative dispute resolution is easy to say, but it's about engaging with the scenario that gave rise to the complaint. What's really at issue here? Am I just angry that the relationship ended? Am I just pissed off that I got treated dishonestly in the casual encounter? Well, what really is at the heart of the problem there? Deal with that rather than going down the criminal path. Guidelines do exist. The director does have them. We call them discontinuance kinds of guidelines. It's about when does the director say enough's enough. The public interest here is more in pursuing public health rather than public prosecution. Which one is doing more harm than good? And remember, of course, we know that any case that involves people living with, at risk of infection of HIV, is going to involve vulnerable people, their confidentiality, their health, their stress, families, friends, the people who are supporting them on either side are vulnerable, because we're not yet in a community that can deal with HIV and its disclosures and its stigma very easily and quickly. We should certainly prosecute in limited circumstances, but intentionally causing serious injury is a charge which is very serious, attracts a 20-year maximum. We don't need special HIV laws for that. It's just not working, it's not worked, and it's not actually used very much. We don't need it. Thanks.
Thanks, Simon. That's a lot of knowledge, and the law is a body or a territory that is very complex. So it's great to have that overview. What I'm going to do now is invite Simon and Paul to come and sit. It looks as though they're going to do a cabaret performance, but they're not. We're going to stick to a discussion on the law. They're going to come and sit over here and answer some of the questions that you might have. Just to reiterate, we won't be filming people asking questions, so that any questions that are asked from the audience will be subtitled, and we will be filming the response. I will answer any questions that come up on the papers that you have, and that will be filmed. John Manwaring over here is going to come and collect any questions that people want to hand up, and Harry has got a mic that he's going to bring around for anyone who wants to add to the question that I ask or ask a question themselves. And while they're doing that, Carrie, can you just hold that form up? There's an evaluation form. If everyone gets a moment, if they could just give us their views on this forum, because we want to really use that to inform future forums, but we'll collect those at the end of the event. James, where was the roaming mic? Yep. Harry will just get that. And if anyone wants to hand any questions up, John will get those. And if anyone wants to ask a question, we'll do that now. Do you want to come and sit over here?
Discontinuance decisions are made by the director, so it's at a high level in the prosecution's office, and the director has a range of guidelines about a whole range of different issues in relationship cases, and that's probably about the closest that the current director's guidelines get to HIV transmission cases. That relationship cases, the director has to consider the relationship, how long it's been going, is it still going, what's the nature of it, who's going to get hurt out of publicising it, who's involved in it and what have been the consequences. So clearly a case where there's an assertion that there was exposure or transmission in an ongoing relationship where there was a hiccup and a complaint made, but actually the relationship is more important than a prosecution, arguably, the director might say, look, no, I'm not going to continue with that. There are other ways of dealing with this and it's more important to rebuild. Another case might be a casual encounter with somebody who's known to be a risky player and is continuing on to have a number of sexual partners or share needles with, etc., and that there is a real problem afoot. There might not be any of those relationship issues that would encourage a public health approach to another. So the answer is the director has to make the decision. Of course, the lawyers under the director will be advocating for it, against it, whatever, and it'll be dealt with in a fairly principled approach. Problem is in Victoria we don't have an HIV transmission or exposure guideline specifically, and depending on the circumstances, the director will refer to a range of different guidelines with those different issues. Probably because guidelines don't bind the director. They're not internal rules that he has to follow to the letter. They're guidelines. They're about these are the issues you have to consider in weighing up whether to go ahead or not.
We certainly, I think I can say for both organisations, take the view that preventing people who are HIV positive from working as sex workers is a form of discrimination. It's unjustified. We're heading quite likely towards a situation where if you're HIV positive in Victoria, you can work as a surgeon but not a sex worker. And I think it's insulting to sex workers to criminalise them in that way. People do trip up on that quite regularly. It's a lower level offence, it's a fine-based offence, but that obviously can still have really significant impacts on people's lives. So certainly I think I can say both organisations would be of the view that that law should change, but we don't have a current plan around that, particularly because that's, we would see that as something that the sex worker organisations should take the lead on, but we would be supportive of. Section 19A is the only HIV-specific criminal law in Australia. There are other laws in other states. Queensland has a disease transmission law. It doesn't state which particular kinds of diseases, for example. Other states simply use their kind of grievous bodily harm or serious injury type laws, and as Simon said, we still have that kind of law to fall back on in the event that some case came up in the future. So there are no other HIV-specific criminal laws, but there certainly have been HIV criminal prosecutions in almost every state. Victoria has the unenviable record of being the worst state in Australia when it comes to HIV prosecutions. South Australia is fighting for the top spot, but we're still well ahead of them. So about half of all the prosecutions that have occurred in Australia happened in Victoria, and most of the rest of them happened in South Australia, but they have been in almost every state. I don't think prison's the best place for anyone. Should people with HIV be imprisoned if they've broken the criminal law and a prison sentence is appropriate? Then I don't think the fact that you're HIV positive should exempt you from prison. I do think people with HIV are entitled to appropriate and appropriate treatment in prison that's responsive to their needs.
I've got one from the floor. Sorry, does that answer the question? I've got one from the floor here. It relates to PrEP, condomless sex in the law. I'll just read it, and I hope I'm reading it properly for whoever wrote this down. Recent PrEP studies prove that when taken as directed, PrEP is more effective at HIV prevention than condoms or condom use. What view would the law have in a case where a positive person had a condomless, sex with a person taking PrEP as directed?
I think that's my question. I don't have an answer. I can't, as a lawyer, give any advice about given situations. Okay, so there's the writer. What I can say is that criminal prosecutions are unwieldy and long and often contested. Even when you're on one side, of course I always think this on my side, is that I have a very reasonable position, and why don't the other side just agree? So, you might have every faith in PrEP, and PrEP may well be very effective. But you've seen the list of names of people that you've got to convince or are going to be involved in this decision. If the scenario in which the encounter happened was one that would upset the morals of ordinary Joe Plod at the corner cop shop, you might well find yourself charged. You might find yourself facing lawyers who get involved and should be dealing with this on a principled basis, but think that it's their duty to protect the community by continuing the prosecution because the circumstances call for it. It upsets the public morals. Criminal law is a moral issue, and that's why we have them, some would say. But there's no discounting it that if the science continues on the way it's going with PrEP and other treatments, that's going to be a very powerful argument. I just can't tell you that it's going to win at the first stage. You might have to keep fighting for a couple of years until you get people to agree. It would be wrong of me to say, yep, PrEP fixes your criminal liability problems. I can't say that.
The other thing too, I think, is that the courts, they don't lead from the front in terms of understanding changes in society or changes in science. And whether you're talking about PrEP or you're talking about treatments as prevention or you're talking about whatever future technology comes along, the courts will take time to catch up to that. The courts have always taken a long time. They tend to take a most conservative view that's available to them. While until 2009, it wasn't clear in Victoria that you could consent to have sex with a HIV positive person if you were HIV negative. It takes quite a while for the courts to catch up.
Can I just add to that? Evidence is also the key in criminal cases. So you might think, I'm engaging properly with PrEP, but have you got proof of it? Can you demonstrate it? Or have you simply told the practitioner 6 months later, oh yeah, at the time this happened, yes, of course I was on PrEP, there's no problem. But can you prove it? So it's a matter of evidence. What does the evidence show?
100% agree
Yeah.
with you. I probably was a bit clumsy before in what I said. What I meant was that we would follow the sex worker community in that regard rather than try and bring the sex workers with us, that we were, you know, essentially we wouldn't want to tread on anybody's toes in that regard. But just to pick up on another point that you made, one of possibly the biggest problem with the criminal justice system is the media. It's not the courts. It's the fact that once you're in court, you are fodder for a media that is incapable, apparently, of reporting on HIV issues without becoming sensationalist. So, a few years ago, I dealt with a guy, not a sex worker, but he was charged by the police and was charged under Section 19A. He appeared in court for a bail hearing, and his case was spread all through the media. It was in The Age, it was in the Herald Sun, and he was, HIV man, charged, he's going to jail for 25 years. Now that guy, he was a guy who was on welfare, a fairly vulnerable kind of a position, lost his job, lost his home, couldn't go out to a gay bar without people coming out and saying, you're the guy who's been spreading around HIV. All the charges were dropped, all right? There was no evidence. It was all a storm in a teacup. So he was never prosecuted, but his life was, he can never get that back. You can never get that back. Your HIV status is now public knowledge. That's one of the biggest problems with the criminal law. Simon would agree that one of the great strengths of the criminal law is that it happens in public. But one of the great strengths of the public health process is that it does happen behind closed doors. There's no need to just break people for the sake of breaking them. So that's why we prefer that system.
Are there any further questions from the floor? Yeah. So, sorry, just so we can capture it for the recording, can I just get you to ask?
Don't say capture to a criminal lawyer. It's a bit scary. Yeah, the new development after the 2009 case was that you can consent to a risk, but you can't consent to transmission per se. What the prosecution prove under 19A is that you at least have a hope to transmit, even if you really believe that it's improbable that it's going to actually happen. If you had a hope or an intent or a purpose to transmit, perhaps because that's the talk, and remember this is all about evidence, so somebody reports that they heard you saying, I'm going to do this at this party, or I'm going to do that with that person. If there's an inkling that this was an expression of an interest or purpose or hope that transmission occur, even if it's improbable and you thought your load was pretty low and it was a pretty minor risk, it's the intention that's the crime. So there's no defence of informed consent for that. It's only in circumstances where you knew that there was a likelihood that there would be a risk that the other partner can say, look, I'm happy to go with that risk.
Is there one? Vic. Thanks.
That's something that we would like to kind of look at in the prosecutorial guidelines process, but we haven't got that far down the track to getting to the point of drafting them at this point. We certainly would have, we're using as our model the guidelines were adopted by the Crown Prosecution Service for England and Wales in the UK. That was a really successful model where community engaged with prosecutors to produce a set of guidelines, and there were some swings and roundabouts in that process. It opened a few cans of worms, but the overall result for the HIV sector in England has been a real reduction in the number of people prosecuted and a real certainty about where the line is. I mean, that's one of the things that we lack. We can't really tell people, here's the line, and as long as you stay on this side of it, you'll be all right. And it's a bit of a lucky dip who gets reported to the police, who gets reported to the health authorities. Or an unlucky dip, I should say.
Any more questions? We've just got a couple of minutes. No more questions from the floor written? Okay, thank you very much for coming along. VAC will be having another forum on it's a hypothetical as part of Midsummer. Think Jeffrey Robertson's hypothetical on use within our community. That'll be on the 20th of January at the Town Hall. So that's our next public forum, as it were, and we hope some of you can join us there. I encourage everyone to fill out those evaluations. If people need a pen, Harry will hand one out to you, and maybe if you could just hand them to Harry at the exit over there. I'd also like to thank Living Positive Victoria for being our partner again at this event, and particularly Paul Kidd and Simon Moglia, who, as I said, has given up a lot of time while conducting the trial. So it's great to have your support, both of you again, and hopefully we can get the changes made by mid next year. So thank you again.
Count on it.
Thank you, and happy World AIDS Day.